So welcome everyone on behalf of ICDR Y&I to this event. I'm Rafael Carmona. And as you know, we're going to talk about how to obtain discovery and document production evidence in general in a transatlantic setting. I want to, first of all, take a moment just to thank all of our panelists and the organizers of the event. From our end, I know Yael, Ripko, and Jessica Vies have worked hard, and I also want to thank our colleagues from DIS40, and Johanna will talk about DIS40 in a moment. I want to say from ICDR Young and International, if you want to join us, you can visit our website. If you look for ICDR Young and International or ICDR Y&I, you'll find us. You'll see there we have some forms that you can use to join. You'll also see our webinars that we've been recording and uploading to our website. And if you want to also keep informed of our initiatives, but you don't have time to complete the form, you can go to our LinkedIn group, ICDR Young and International. We'll also be posting there all of our updates and initiatives that we think you might find interesting. So with that, I leave the floor to Johanna Boostings. I'm pretty sure I mispronounced your name, and I apologize for that, Johanna, but the floor is yours. Okay. Thank you very much.
That's okay. Yeah, hello, also welcome from my side. It's great that you all joined this event that ICDR Young and International and DIS40 organized jointly. DIS40, as some of you may know, is the below 40 organization of the DIS, the German Arbitration Institute, and it's a platform for young arbitration practitioners to network and exchange practical experience, as we also do today. You can also join DIS40. It's also for free on the new website, disarb.org. And I also want to thank Tim Rauschning. He's a senior associate at Luther in Hamburg and a regional coordinator for DIS40. And he had the idea for the topic and for this cooperation between ICDR Young and International and DIS40. So special thanks to Tim. I will now just introduce the moderators and speakers to you and then inform you quickly about the course of the event. We have two moderators and two speakers. As moderators, I would like to introduce Gretta Walters. She's a counsel at Sherwitz Lindsay in New York City, and she's specialized in litigation before US state and federal courts, as well as in international arbitration, both relating to commercial and investment disputes. Gretta, it's really great to have you on board. And from Germany, we have Felix Dörfelt. He's a partner at Edelshaw Goddard in Hamburg. And he also works in the fields of international arbitration and litigation. And he also acts as arbitrator and mediator. As speakers, we have on the one hand, Jennifer Bryant. She's an associated partner at NER in Düsseldorf, in Germany. And she advises and represents clients in complex civil, commercial, and corporate disputes before German state courts and arbitral tribunals. And she also has experience in advising clients with respect to discovery proceedings in the US. So that would be very interesting to hear her experiences in this regard today. And then last but not least, we have David Pinsky. He's a partner at Covington in New York City. And his practice also focuses on both commercial and investment arbitration, often arising in Russia and Eastern Europe and in the energy sector. And furthermore, he also represents clients in US litigations, including litigations in support of arbitration and implications for discovery under Section 1070-82, which we also, or the panel will broadly discuss today. And as to the course of the event, we will now have approximately 40 minutes of panel discussion, and the audience is welcome to pose questions at any time using the chat function in Zoom. And then the moderators will pick up your questions. And after that, we will have approximately 15 minutes of networking in breakout rooms with, we will see how many, but maybe 5 to 6 people. And you will be automatically distributed to those breakout rooms. So there's nothing you have to do. And it would be great if you would stay and participated in this networking. And after that, everyone is sent back to the main room, and then we will close the event. So now I give the floor to our panel. Thank you very much.
Well, Johanna, Rafa, thank you very much for organizing everything, and thank you for thinking of us. What we intend to do today is to give you a live interactive discussions with our speakers on how to obtain evidence. And we'll start off with a practical example. We have an ICDR arbitration seated in London with the German party G as the claimant and an American party A as the respondent. And I'm one of the clients, and Gretta and David, I think I heard their evidence, in particular documents in the US that would be interesting for us to get for that arbitration. What can I do to get them?
So thanks, Felix, and thanks everybody for joining. So from a US perspective, if you're looking for documents in the United States and you're a party to a private arbitration that's seated in London, you would be thinking about Section 1782, and it's 28 USC Section 1782, which for those of you who aren't familiar with it, and Felix, if you're my client, the statute, which is up on the screen here on the left side, it permits, just generally speaking, it permits parties to legal proceedings outside of the United States to obtain evidence from entities or individuals located in the United States. And there's a couple of qualifications to that I'll mention in a second. The background to Section 1782 is that the US Congress enacted it to further 2 goals. The first is to provide efficient assistance to participants in international litigation, and second, to encourage foreign countries, by example, to provide similar assistance to US courts. So that's the background to it. The qualifications is, in Felix, if you're my client, what I would ask you first is where this evidence is located, because go ahead, Felix.
Let's say Chicago.
Okay, so if it's Chicago, Chicago is located in the 7th Circuit, which for those of you who aren't familiar, who are located outside of the United States, the US federal court system is divided into 12 circuits, and different circuits have applied Section 1782 in different ways. There are 2 circuits that have held, and that's the 4th and the 6th Circuit, which have held that 1782 is available in support of private arbitration, but there are 3 circuits, including the 7th, where Chicago is located, which has held that 1782 discovery is not available in support of private arbitrations. So based on just the simple facts that I know now, if you just have a private arbitration located abroad or in London, you would not be able to get 1782 discovery in Chicago. I should add, and I'll turn it back to you, Felix, in a second, this division among the circuit courts in the United States is what's called a circuit split. And there is a party that recently applied for 1782 discovery in the 7th Circuit, and the 7th Circuit found that it was not available to that party. And that party is now seeking relief in the US Supreme Court on the basis that there's a so-called circuit split, which is when different federal circuits approach the same issue of law differently. That's an issue that the US Supreme Court which would interest the US Supreme Court. It doesn't necessitate that the court would actually hear the application, but that's the type of case that the court would be interested in. I'll turn it back to you, Felix.
David, thank you very much. Well, it's really, I'm not sure, I can't see Gretta anymore. Gretta, you still there?
I'm still here, yes.
Yes.
So if I can, with Felix, also one of the clients and very interested in this, and I forgot to mention to Felix earlier, we actually also have some documents in Maryland, which I think is the Fourth Circuit. It's my home jurisdiction, so or my home state. So I know one of our opponents has some documents there that we're interested in. Dave, I understand that at the moment is an okay circuit to get this. So, I mean, if we were to apply for documents there, what, practically speaking, I mean, what could we ask for? Who should we request it from? What time should we do it? Just how does this work as a practical matter in the circuits where it is available in the US?
Yeah, so as a practical matter, I want to also just talk about some of the factors that the court would consider when you apply, even in a district court in the Fourth Circuit, in which this type of discovery is available. But as a practical matter, as many of you know, the U.S. discovery is quite broad. So the documents that you could get are potentially a quite broad category of documents. And I'll speak in a second about how you would go about getting those. But just briefly, the factors, there are so-called mandatory statutory factors that the court would consider if you submit an application for 1782 discovery here in the Fourth Circuit. And then there are discretionary factors, which the court has discretion in applying. And based on the language of the statute that you see here on the screen, the statutory factors are, there's 4 of them. You have to be an interested person first. Second, in a proceeding in a foreign or international tribunal, and the Fourth Circuit interprets that to include those types of tribunals to include private arbitration. And third, you would have to seek evidence from a person or entity that resides or is found in the district court in which you're seeking, or in the district over which the court in which you're seeking discovery is located. And fourth, for use in a foreign proceeding. So those are the statutory factors that you would have to satisfy. In terms of the discretionary factors, there are 5 of them. The first is whether the party from whom discovery is sought is a participant in the foreign proceeding or is already subject to the jurisdiction of the foreign tribunal. And if that's the case, you're less likely to be able to get Section 1782 discovery. And 1782 discovery is typically sought from a non-party to the underlying arbitration, or for example, from an affiliate of the party to the underlying arbitration over whom the court does not have, or I'm sorry, the arbitral tribunal does not already have jurisdiction. The second discretionary factor is the nature and character of the foreign proceedings. The third is the receptivity of the foreign tribunal to judicial assistance. So if the foreign tribunal is receptive to it, that will certainly help you. Fourth is whether the request is an attempt to circumvent foreign discovery restrictions. And if it is, you're unlikely to be able to get 1782 discovery. And fifth, whether the request is unduly burdensome or intrusive. So if you're able to satisfy those factors, or a court applies those factors in your favor, the category, to Greta, to the core of your question, the category of the document, the types of documents that you could get are quite broad because of how broad US discovery is. So I'll stop there.
Yeah.
And Dave, I do have a question. And is that right? Am I right to assume that you can even make use of 1782 before the tribunal is constituted? So before you even went to arbitration?
Yes. So if you want to increase the likelihood that you're going to get what you want to apply for the discovery, for the 1782 discovery as early as possible. And that includes before you've actually commenced the arbitration. And what the court will ask you is, are you truly contemplating this arbitration? Oftentimes, like where I personally have been most successful in getting 1782 discovery in advance of commencing an arbitration or a proceeding is when you can actually put a draft request for arbitration, or a draft, if you're in a foreign court, or a draft complaint as an exhibit to the application itself. But yes, you can get it early. You can get it before you commence the arbitration.
Jenny, to follow up with you though, it sounds like there's some documents in Chicago that the US courts can't help us with. Is there anything from a German perspective that could help us to think about how to get just sort of any sort of discovery, documentary discovery in the US?
Yes, indeed, we might make use of 1050, and maybe to take a step back and just walk participants, especially the US participants, through the basics of 1050, and then to discuss in a second step how to utilize that to potentially get documents in Chicago. So I think the main 2 or even 3 differences compared to 1782 is as regards 1050 of the German Code of Civil Procedure. It's also a provision that provides support, provides aid by state courts in aid of domestic and foreign arbitral tribunals, arbitrations. But I think one difference is the timing. So that provision only applies after the arbitration has commenced and the tribunal has been established. Why is that? Because basically it is up to the tribunal to make that request. It's not up to the parties. If the parties went to make a 1050 request, that would only be possible with the authorization of the tribunal. So it's basically the tribunal would be the plaintiff in those proceedings. That's one difference. I think the second difference is, or it's something that needs to be talked about a little more, is the fact or the question of whether you can get ex parte support. Here it is that basically the courts would decide per an order as opposed to a judgment. And that means that the courts generally, as a general rule, would decide in writing without oral hearings. And if it's the tribunal that would make that request, at least by virtue of law, there is no obligation to hear the parties before that under the state court. So the second question would be, would the tribunal have to have the parties consent or have to hear the parties before making that request under the applicable arbitration rules? But under the German Civil Code of Code of Civil Procedure, the arbitral tribunal would not have to, or the state court would not have to hear the parties before making that decision. It would be different if it was one of the parties who made that request with the authorization of the arbitral tribunal, because in that case, there would be an actual opponent, meaning the other side, the other party to the arbitration, and then that party would need to be heard. So in that, you could not have ex parte decisions anyways. And then the third, and I think that's the main difference, is the background and the scope of the support that you can get. So the background of 1050 actually is help with witnesses and support by state courts with administering oaths, things like that, because that's something that arbitral tribunals cannot do. Anything that needs coercive measures or compelling the witnesses, that's something where you would use 1050. But 1050 can also be applied with respect to getting documents. But then, at least if it's documents that are situated in Germany, there's a very restrictive, limited application scope for that, because Germany, for those who might know or might not know, under German law, we do not have discovery of documents in the sense that the US knows it. We do not have pretrial discovery at all. So all the measures, Germany even declared on a reservation under Article 23 of the Hague Evidence Convention. So with that, in that respect, there's a very limited scope of the possibility to get documents. in Germany. But, and coming back to your question now, what you can do is you could go through 1050 potentially if we had the arbitration was seated in Hamburg, for example. You could go through 1050 and request the German state court to request the Chicago courts to help. And I understand under 1782, the German state courts would indeed be eligible to make that request.
Danny, I think that's a really neat way, if possible, to circumvent some of the restrictions that are caused by the circuit split. But my next question would be, David, you said I could get documents in Maryland, but imagine now the US respondent has a daughter company, some subsidiary is situated in Germany, and I want to get documents there. Is that also possible, or do the documents have to be located in Maryland as well?
Yeah, it is possible. Just first, I thought maybe we could take the I don't have control over the slide, but maybe take the slide down.
Slide down. Yeah.
So the short answer is yes, and it depends. So it is possible, depending on the court that you're in, and here if you're in a district court in Maryland in the Fourth Circuit. I haven't looked at the case law there, but generally the test that the federal district courts in the United States will apply is they'll simply look to the practical, like whether the party that's subject to the discovery can, as a practical matter, get the documents. And it doesn't matter if the documents are located in Virginia or if the documents are located abroad typically. But again, different courts in different district courts and different circuits approach this differently. And sometimes different judges in district court in Maryland will approach it differently. But as just a theoretical matter, it is possible to get.
Okay, understood. So you really just have to need a person there or a company situated in the district court, and then depending on whether they have control to get documents that are outside of that district. Yeah, that would work.
If you're able to show that as a regular course, the party in Maryland that's subject to the discovery can simply ask and then get documents from its subsidiary or really any affiliate that's located in Germany, that will help you, and you may be able to get the documents.
And Jenny, how about with the German courts under Section 1050? I know you mentioned some what might happen if the seat was in Hamburg, but if in our hypo we have where the seat is in London, is that the type of situation that the German courts could help get documents located in Germany?
Yes, if the documents are located in Germany or if the witness is in Germany, that would be applicable as well. So 1050 does not distinguish between whether it's a domestic or a foreign arbitral tribunal or arbitration, and it does not distinguish between what is a tribunal in the legal sense. But if it's an arbitration, whether commercial or investment, that could be applicable.
Felix, I'm feeling better about our case. I think we might get these documents.
We're making headway.
Definitely.
Maybe something, because I'm a lawyer and I always need to get expectations down.
Dave did tell us
to not make you happy. So you pay me more and I find new ways. But so indeed, you might get those documents. But if you rely on 1050, as I said, as regards documents, there's a very narrow scope, and you would have to go through its German section 142 of the German Code of Civil Procedure. And that allows for a very limited document production, but you would have to designate and describe the particular document. So it's not a category of, provide all emails from, I don't know, 2010 through now. Between those 5 participants, and then I might find what I need. But it's really, there's a specific document you need to show it's not in your possession, but instead in the opponent's possession, the other party or the third party. You have to show why it's relevant to your case, and why you need it now and why the other party can produce it. And then there's discretion, for the German court to decide whether or not to order that production. And if the state court does decide to order that production, it's still not mandatory in the sense that if there's no need to comply with that order, but it would be then up to the tribunal to weigh that and to credit that and to draw adverse inferences, for example. But the German court could order, but it could not compel the production by any means.
Jenny, I think you just successfully clouded the prospects of success for our case. Gretta, do we have witnesses that we want to look at?
So I definitely do. I have some people in mind that are both in the US, Germany, and maybe France as well, that I think would be really helpful to examine. From a US perspective, I'd love to depose them for 10 hours, maybe a couple of days if possible. So I don't know what you're feeling with Felix, but I think that could really help us build our case and maybe be successful ultimately.
Yeah, definitely. And Jenny, because most of the witnesses are in Europe, do you want to go first and explain us whether we have possibilities to get a hand on them?
Yeah, sure. So basically, the same prerequisites would apply with respect to the witnesses. So again, as far as the proceeding goes, you would have to go, the tribunal would have to go and make that request, or one of the parties with the tribunal's consent. The court would decide by order without oral hearing, unless there is need for evidence, for example. And then when we look at the question of a deposition as such, that indeed, because again, depositions are not known to German law. What we have is witness testimony taken by the court, by the judges, basically with some additional right to ask questions by the lawyers. So what would happen is under 1050, the court would request the witness to show up in court, and then the judge would make the examination of that witness and take the testimony, possibly with the help of the arbitral tribunal that could also submit questions and the lawyers as well. But it's not a deposition in the sense that you would have in mind, where you would sit a private room without any judges and take a videotape deposition with an oath administered, because that is not allowed under German law. Or with it's not allowed, but there's a possibility, but only you would have to get the authorization of the German ministry, and then you would have to go through to the US consulate in Frankfurt and sit in their very tiny room without any air conditioning. That closes, I think, by 6 o'clock. And do it. So there's a lot of obstacles to that, and we might want to talk about moving that to France or the Netherlands or something close to Germany.
I mean, that makes sense. So I understand we first have to go through the tribunal and apply for them, and then they'll go through the court. But can we get only the witnesses in Germany, or can we, I mean, you mentioned the court help. Can we also go to the French or US witness?
Can we go, I'm sorry, I did not understand that. Can we go to
Can we also get the witnesses located in France or the US with the German court help?
Well, again, we would try to get those documents in Chicago. We would also, again, ask the German court to request whatever court help, state court help they could get from the foreign courts, possibly under the Hague Evidence Convention again, to compel those witnesses located in France or London or the US to appear in front of those courts and be questioned there.
Okay, that sounds good. But Gretta, you wanted to do depositions. Maybe we should turn to the US, and Gretta, David, can we get help in the US to do our depositions?
Yeah, I think that's important. I agree.
So the way it might be helpful just for folks and for you guys as the clients to understand just what a 1782 application typically looks like, because it relates to depositions. Typically, a party will apply we'll have an application. That's the first document. That will be an application for discovery. And behind the application will be a list of the documents that you want. And then behind that will be a deposition subpoena. And typically the parties will get the documents first. And then if you want a deposition, the deposition would be typically questions about the documents that you got. And if the witness is located in the United States, you're likely to be able to get that deposition in the United States. And I don't know if if Felix and Gretta, if you have in mind a particular person that you want to depose, but often what the deposition subpoena seeks is someone who's most knowledgeable about the topics that the documents cover. And then the entity, if your application is serving an entity with discovery, they get to decide who that person will be. And oftentimes in negotiation.
Just to recap, so I'm thinking I want to get somebody from Coca-Cola. So I say, Coca-Cola, please give me your employee who's most knowledgeable on that topic. Is that how it works?
That's typically how it works. And Coca-Cola can decide who that is. They can also find a person who actually doesn't know that much, at least initially, about the topics and educate them as a so-called corporate representative, or what we call in the United States a 30B6 witness. And that person could be located in the United States, or if Coca-Cola, if the issues in the case have arisen in Europe, Coca-Cola might have a European, somebody in London, for example, or somebody elsewhere in Europe, who they themselves offer as the witness. Even though that person isn't located in the United States, simply because it makes sense from a practical perspective for that person to be testifying if that person knows the facts that are at issue in the deposition in the 1782 application.
Dave, with respect to the depositions, if we were able to depose someone in the U.S. though, I mean, what could we get as a practical matter? Are there? You mentioned 30B6 of the Federal Rules of Civil Procedure. Is that where we look to the limitations as to where the deposition can take place, when, how long, things like that? Or are there separate standards we look to under 1782? Or again, is the answer, it depends on the jurisdiction, really?
It depends. So it largely depends. So if you're looking to file an application for 1782 discovery, after looking at the statute and the factors that I discussed earlier, you're going to want to look at the local rules in the district in which you're seeking the discovery, because those local rules may govern things like, for example, the practicalities of the deposition. They may govern things like the practicalities of the application itself and how you bring it, when you bring it, and what notice is required to the other parties. But typically, like on the time limit, Gretta, that you alluded to, like typically a 1782, a deposition in the United States typically is a business day. It's about 7 hours.
And that can
maybe,
sorry, Jenny.
I just want to say, add something maybe positive for your case. So I'm not only the one who has the bearer of bad news. So if you went through 1782, deposed the witnesses, or even got very broad discovery requests, the good news is that would not make the lead to a set-aside proceeding in Germany as regards a later award, for example. So that's something you could still enforce the award in Germany, even though we do not have discovery in German law. German law does not allow for discovery measures. But if that happened and you were to bring in the award later on, that would be possible, because German courts do not consider those procedures to belong to the public policy in Germany. So that's something that you could still do.
That's good to know. I have another practical question. Felix and I haven't started our case yet, as you both know, as our counsel. And I understand from the 1782 perspective, we can apply for discovery pre-action. In the 1050, we have to file the action. But it would help to know what is the timing of this. I mean, if we file for 1782, a week, a month, 6 months? When do we get the discovery? And same under 1050. Is it something that happens quickly, or do we have to, you know, expect that this could really draw things out, or we might not even get the documents or the witness examination in time to help our case?
Yeah, so it's a very good question. And again, it depends on not only the district court that you're in, but the judge that you're in front of. So certain districts will have a high level of familiarity with 1782 applications, even though they're not available for private arbitration. In New York, for example, they are regularly used for different types of foreign proceedings. And so the Southern District of New York, which is the district in which Manhattan is located, is very familiar with 1782 applications, and you can get discovery, you can get a subpoena the same day that you apply for it. In other districts, like let's go to Maryland, for example. If the judge in the district court in Maryland isn't familiar with the 1782 application, you may find that application is pending for a very long period of time. I've had, not in Maryland, but not in New York, but elsewhere in the United States, I've had applications for 1782 that have been pending for almost a year before the judge acts on it. And even when we're trying to diplomatically trying to get the court's attention to act on the application, it's sometimes difficult to do that. One additional factor that you should keep in mind, just in terms of the speed, typically 1782 applications are filed ex parte without notice to the other side, to either the target of the discovery or to your counterparty in the arbitration itself, in that notice is only provided after as you're serving the subpoena, which allows you, if you can get the court's attention the same day and get a subpoena the same day, it allows you to move very, very quickly. And your counterparty in the arbitration or the target of the discovery, they can challenge the subpoena, but only after the fact. They can move to vacate the 1782 order if they think it wasn't granted properly, or they could move to quash in whole or in part the subpoena if they think that it's overbroad. But the bottom line is, if you're in front of the right court, you can move very, very quickly.
And just as a practical matter, once I have the subpoena, do I already get the documents, or while they're trying to squash it, I'm sitting on nothing?
So once you've served the subpoena, the other side under the federal rules will have a certain amount of time to respond to the subpoena. And typically the response is first not the production of documents, but they have an opportunity to respond and object to the various document requests. And because these are typically non-parties, courts will give typically, not always, but will give the non-parties some leeway in terms of the amount of time that they're given to ensure that the non-party isn't unduly burdened by the subpoena. But courts at the same time, depending on who the target is, may expedite the process. Like I've had situations where I've been involved in 1782 proceedings where the court has asked that the target of the subpoena move very quickly because the court believes that the target of the subpoena has the capability to do so, and that the discovery is urgent.
And how about in Germany, Jenny?
That's impressive. I wanted to say, I think everything moves a little slower here. So I think that the main reason for that is also the competent court would be the so-called local court, which is the lowest court of first instance in Germany. And then I think you would have a wide variety of experience actually by those judges. They usually decide by themselves as sole judges, and have a lot of things on the table that range from, I don't know, traffic injuries through neighbors that fight, through lease questions. And then this. So I think that's something that's really new to them usually. And even that might take time. And I think a day, that's something that's merely out of question. It would take longer than that. I think the fastest way would be indeed if the court decided in a written proceeding without any oral hearing, without any evidence taking. But still, I think usually the court would just, they would get the request, and I would assume they would serve it to the parties just to get their comments, and then they would decide. So I would tend to think that something less than 6 months would be very, very quick.
Well, I agree, but once the court has made its decision, it doesn't move much faster afterwards. I mean, summoning a witness and setting a hearing date takes 3 to 6 months, depending on really where the local court is situated and how eager that specific judge is to deal with that certain matter. So I assume a similar experience than in the US, where some judges just like to let it sit. And
just maybe again, to add something, Felix, I mind again, the court can order, but the court cannot compel. So if the target of that request was to deny and maybe even file appeal against the order, they would simply not adhere. And the only consequence they would have is that they, in the arbitration, that they might see some consequences there as regards, the decision of the tribunal.
But that's documents, and with witnesses it's different, and that's really the reason why Germany put the 1050 in there. They're saying, well, in Germany we believe the judge leads the taking of the evidence, and so the tribunal leads it. And once the tribunal can't summon or can't force a witness to come to before the tribunal, that's why the courts are supposed to help, and then they can court order the witness to come. And if the witness doesn't come, they'll be fined, and in the extreme cases, he'll be sent to jail for not complying with the court order. And so, whereas on the document side, the German discovery or the German help is very weak. On the witness side, it's fairly strong, because especially as Jennifer mentioned, it's a possibility to also then, through the Hague Convention, access witnesses all around the world. And in Germany, it's generally accepted that is one of the reasons or mechanisms that 1050 should be used to access witnesses in far away countries where you have really otherwise, from the tribunal side, difficulties to reach them there. But I think we see a question. Johanna has asked us about the costs of the discovery. And I think that's very, very important for us, Gretta, because we don't want to pay for that discovery. We just want to get the evidence. So maybe Jennifer first, and then David, can you tell us, in your respective jurisdictions, how does it work with the cost? Do we have to pay for it, or does the party have to pay for it?
I'm not sure I understand the scope of the question. So the cost of getting the discovery, or the cost of the 1050 proceedings? So as regards to the cost of the 1050 proceedings, you would deal with that within those proceedings, and there are statutory fees that apply, and that's something that you could get back. And then, at least if it's an arbitration under the DIS rules, for example, the tribunal could order those costs as reimbursement as well.
Okay, but we would have to advance them to the court. Say they want to have a witness travel to Hamburg to be interrogated before the court. Will have to advance all those costs.
Yes, the party who wants that needs to advance, and then you would have a reimbursement claim.
David, how's in the US if we want to get documents, and electronic discovery is expensive, I heard. Do we have to pay that, or is the responding party the one who has to pay for the discovery?
So the default rule in the United States is that the party that's served with the discovery has to pay for it itself. So the target of the discovery, but the target of the discovery, particularly if depending on who that is and what types of resources they want or they have, and the scope of what's sought from them, and if they have any connection to the underlying arbitration, they can make an application to have their costs covered. But the default rule would be that you, as the petitioner, would not have to pay for it.
That sounds great. Good, Greta, what do you think?
That sounds great. Yeah, I don't want to pay for anyone to have to fly anywhere. Or, you know, I know Dave and Jenny are expensive, so their costs to prepare for these depositions, I'd like to avoid the other side's lawyers too. We have a couple questions coming in now. Maybe this one goes more to Dave. The question is, does the discretion of US courts tend to disfavor discovery if the order would circumvent local procedural law, for example, at the place of arbitration? So I guess the question is, how much do the US courts in applying 1782 consider maybe what is discoverable or procedures in place either at the seat or of the arbitration, or maybe even where the witness or the discovery is located?
Yeah, so I would distinguish on the one hand where the procedures in the foreign jurisdiction, whether it's the seat or where the witness is located or where something is located, whether the procedures simply don't provide for the discovery versus where the procedures affirmatively disallow it for some policy reason. And in the latter instance, that may create a challenge for you. That's one of the discretionary factors that the US court would look at. But if it's just that the discovery isn't available under the procedures in whatever local jurisdiction you're in, then that wouldn't necessarily create a problem for you. And in fact, that's probably one of the reasons why you're in the United States to begin with.
And maybe just to add to that, I think, Dave, if your experience has been the same, I think for the most part, you know, things like, you know, the difference between what you and Jenny have discussed in terms of scope of discovery that's allowed under the German law perspective and the US law perspective, where it's quite broad with 1782, where it's much more narrow with under German law. I don't think a US court would really care, for example, in terms of scope, what German law says, if it's allowed under US law in terms of discovery. And you're right, there's no public policy concerns. I don't think a court in the US would even really consider what the German perspective is in terms of scope. Has that been your experience?
Yeah, that's been my experience. And what the oddity that this presents for many foreign parties is that you could have a situation in which the discovery you seek from a non-party and that you get from a non-party in the United States is actually significantly broader than the discovery you're getting from your counterparty in the arbitration itself, simply because a Section 1782 document subpoena at least in theory, could have the same scope as any type of document subpoena in the United States. And those, fortunately or unfortunately, those can be quite broad.
But that's really interesting. Just one more question that came up. David, would that change if our arbitration were seated in New York? Mm-hmm. Would we still have the same breadth of discovery, or would the court aid be different?
So it's a good question. So first, because it's a U.S. seated arbitration, 1782 would not apply. So you wouldn't be able to get a 1782 subpoena. But if you're my client, we have a New York seated arbitration. One question I might ask you is, like, a lot of times international arbitrations, they're a multi-headed beast that has some sort of parallel proceeding in a different jurisdiction. So there might be a parallel judicial proceeding connected to the New York seated arbitration that you could seek the discovery in support of that if you needed it legitimately in support of that. But there are other avenues to get non-party discovery in the United States if you have a New York seated arbitration. You could, in New York, the arbitrators would have the authority to sign off on a non-party document subpoena that you wanted to serve on a non-party, but with certain limitations. So there's a rule that says that the person or the entity has to be located within 100 miles of where a majority of the tribunal sits. And that creates all kinds of interesting questions, like where is the tribunal actually sitting? Can you move the tribunal temporarily somewhere so that they're seated near someone else? The practical reality of it is, if you want document discovery from someone in the United States, it can be expensive to oppose it. So sometimes parties will just voluntarily give you what you want, even if you might not be entitled to it if they were to fight you. So it just depends on how much it's going to cost to fight.
Greta, so we're back at costs.
This sounds like it's going to be expensive.
yeah, it does.
Dave, how does it work if you have a government party involved? Because that's, you know, basically there you have a great shot in Germany, even under the Freedom of Information Act, to get a much broader sense of discovery, even to the extent of, you know, more or less fishing expeditions. That's something, you know, we have a very broad scope of right to get information. Is that something that you can utilize in the States as well?
So if I would first go to, we have our own freedom of information provisions, both at the federal and at the state levels, So I would go there first before thinking about 1782. I personally haven't used 1782 for records from a state entity or a federal entity, as opposed to freedom of information laws or acts.
Okay.
Yeah. I think that's, Greta, I'm very well advised by our two lawyers. Do you have any questions to conclude?
I think we have a lot to think about, and we need to go back to the drawing board about where we want our documents and our witnesses to be. But I feel like we're in really good hands with Dave and Jenny too, and I feel like we're going to be successful at the end of the day.
Well, David, Jenny, thank you very much for your legal advice. Greta, for being a great co-client. And I think we'll hand it now over to Rafa and Jennifer, and they'll take us to the networking session. Rafa.
Perfect. No, thank you very much to all the panelists for this great presentation that concludes our substantive part of our event. So I will also stop the recording now.